Good evening and welcome to the launch of Volume 46, Issue 2 of the University of New South Wales Law Journal. On behalf of the journal, I would like to begin by acknowledging the traditional owners of the land on which we gather this evening, the unceded land of the Gadigal people of the Eora Nation. I pay my respects to their elders, past, present and emerging, and extend that respect to any Aboriginal and Torres Strait Islander people here tonight. My name is Matilda Grimm, and I am the Executive Editor of the University of New South Wales Law Journal. It is my great privilege to commence tonight's official proceedings for the launch of Volume 46, Issue 2, a part thematic issue on the topic Life Sciences, Ethics, Innovation and the Future of Law. The journal owes its gratitude to Premier Sponsor Corrs Chambers Westgarth for hosting us tonight for the first time in their new office. We are very grateful for Corrs' continuing support, without which much of what we do at the journal would not be possible. My special thanks to Cassandra Galea and Marianne Saliba for all their work in making tonight possible, and also to Eugenia Kolovas, who will be speaking on behalf of the firm shortly. I would also like to recognise the very generous support of our other premier sponsors, Allens, King & Wood Mallisons, and Herbert Smith Freehills. We are immensely excited to welcome tonight the Hon Justice Robert-Beech Jones, Chief Judge of the Common Law Division of the Supreme Court of New South Wales and a Judge on the New South Wales Court of Appeal. Justice Beech Jones wrote the foreword to this issue and will shortly deliver a keynote address on the thematic topic. The journal extends sincere thanks to Justice Beech Jones for making the time to be part of this launch. There are several other people whose support is integral to the journal. Our brilliant faculty advisors, Rosalind Dixon and Gary Edmond, who always lead with a steady hand, and Professor Andrew Lynch, Dean of the UNSW Faculty of Law and Justice, who is a great champion for the journal and whose ongoing support we treasure immensely. We are thankful for Professor Lynch's generosity in agreeing to deliver the vote of thanks at the conclusion of tonight's proceedings. Of course, all this is not possible without the authors whose writing makes up the 430 pages of this issue, some of whom we are pleased to say are here tonight. Thank you for trusting us, those of us at the beginning of our legal and academic careers, with your work and for all your patience as we muddle our way through it. There are various other parties whose direct and indirect support ensures a night like tonight can happen. Printers, typesetters, cover designers, artists, photographers, videographers, UNSW law staff, referees, family, partners and friends. But undoubtedly, the most important contributors are our editorial board members who edit for hours and hours with passion, good humour and rigour. And speaking of good humour, the tireless yet always lively dedication of the journal's executive committee, our currently 5 issue editors, our forum editor and our digital editor, is critical to the success of this journal. Over halfway through my tenure as executive editor, I'm still constantly blown away by the professionalism, wit, and kindness of our executive committee members, former and present. I would like to give a special shout out to our digital editor, Zong Guan, who ensures everything we do appears seamless, even when the opposite may be true. And then there is the person who made this issue come to life and who tonight sadly ends his tenure on the journal's executive committee. Editor of Volume 46, Issue 2, Hayden Clift. I think it is safe to say I speak on behalf of the entire journal community and many others here tonight when I express my deep respect and admiration for Hayden's dedication to the journal and equanimity under pressure. It can be somewhat harrowing to receive a late night message from Hayden that begins with the words, "I've been thinking." Even more so when it's not a text message, but a 7-minute voice message. But you can be sure what follows will be deeply articulate and compassionate and will demonstrate yet again Hayden's commitment to bettering the journal. Hayden, we are so very sad to be losing you, but we are incredibly excited to see what you achieve next. And we know the journal is now in the very capable hands of your successor, Brad Marsall. Thank you to all of you for joining us at the launch of Volume 46, Issue 2 tonight. It is now my great pleasure to introduce Eugenia Kolovas, Head of Intellectual Property at Corrs Chambers Westgarth, to welcome us to the firm.
Matilda, thank you so much for that very warm introduction, and good evening everyone. As Matilda mentioned, my name's Eugenia Kolovos. I head up our intellectual property team here at Corrs, and I'm also a partner of the technology and media team. On behalf of Corrs, thank you for joining us here this evening. We are absolutely delighted to be able to welcome you, many for the first time, in our new offices here at QQT. We hope you've been enjoying the spectacular view over the harbour. I'm sorry we didn't do this during the daytime, because I can assure you the view is even more spectacular during the daytime. So to the students in the room, you'll have to come back when you have all your clerkships that you've accepted and enjoy the great views. I'm joined by a number of my fellow Corrs partners here tonight, as well as a number of Corrs lawyers, so I hope you've all had the opportunity to mingle and meet some of the wonderful people that we have here at Corrs, and can stay around afterwards to continue the conversation. Corrs is extremely proud to be a premier sponsor of the UNSW Law Journal. The relationship between UNSW and Corrs is a truly valued one. We have a strong alumni presence across all levels of our firm, including many in the room this evening. Through our clerkship program, we've also had the opportunity to connect with UNSW's best and brightest students. A couple of months ago, we were absolutely delighted to have several committee members from the UNSW Law Journal join us for our autumn clerkship program, including Hayden Clift, the editor of this volume. Hopefully you all enjoyed your time with us as much as we enjoyed having you. Like UNSW, Corrs places strong emphasis on diversity of thought, integrity, innovation, and deep connections with the community. All of these elements are interwoven with our teaching firm culture, where lawyers are supported to build strong personal connections and develop their skills and knowledge through day-to-day interactions with mentors and on-the-job learning. We are absolutely delighted to continue our support of the UNSW Law Journal now and into the future. With this issue, I must commend the authors and editors for what is another impressive and engaging volume of the UNSW Law Journal. Your fresh perspectives and enthusiasm for the law is so clearly reflected, and the contribution that you have made to legal scholarship cannot be understated. As His Honour so aptly notes in his foreword, the strength of this edition is the diversity of the subject matter covered and the exceptional quality of the articles. The broad topics that are covered in this issue, which Hayden will introduce, rightly focus in many cases on outdated regulatory regimes that struggle to keep pace with technological changes, or which do not have sufficient flexibility to factor in the holistic circumstances of an individual's situation. These are certainly challenges that we face on a daily basis, particularly in my area of practice in IP and technology, when we're providing legal advice. And I think the issues have been so elegantly articulated by the authors. Hayden, I particularly liked your own personal enlightenment that you mentioned in your editorial, that as a, quote, lowly first-year law student, you saw just how important the law remains in our understanding of the virtue we all hold dearest, which is life, and how the law is so much more than a set of prescriptive rules, but the formalisation of a society's moral underpinnings. So to that end, I am delighted to welcome UNSW law student and editor of this issue, Hayden Clift, to introduce the issues and the topic for tonight's launch. Thank you.
Thank you very much, Eugenia, for that incredibly warm introduction. It truly is a thrill to be back here at Corrs actually to launch this issue of the journal. And I will return quite shortly to provide Corrs with a more full vote of thanks, but before I do that, I too would like to start by acknowledging that we're meeting here tonight on traditional Gadigal land, and in doing so I pay my respects to elders past and present, and extend that respect to any Aboriginal or Torres Strait Islander friends, colleagues, or members of the community more broadly who are with us tonight. As Eugenia mentioned, my name's Hayden Clift, and I'm the proud editor of this issue of the UNSW Law Journal. And proud though I may be, I've actually been extremely unsure about precisely what it is that I should say tonight. So unsure, in fact, that I resorted to asking practically every person I know one simple yet quite fundamental question. How does one write a speech that is both informative and entertaining? To this question, I received quite a mixed bag of responses, admittedly to varying degrees of utility. For instance, one friend suggested that given this issue contains a thematic component on law and the life sciences, which is something I will return to very shortly, that I formulate this speech essentially as one long mathematic equation, which is, entertaining to some, I'm sure. But perhaps most concerningly, one person said, and I quote, "Hayden, it's a journal launch. It's not meant to be entertaining." So 2 thoughts on that. Firstly, it's quite offensive. And secondly, I couldn't actually disagree more, because in my mind, the launch of any publication should always go to reflect the kind of spirit and character of the very publication that's being launched. And to me, issue 46.2 of the UNSW Law Journal presents the perfect blend of informative analysis, which the authors of this issue have produced, and mind-tingling entertainment. I say that in a way not to trivialise the high scholarly impact that these articles will have, but more so to say that each of the articles in their own right make for very compelling reading, and they all address their own topical issues of law. Speaking of topical issues of law, as you all know by now, this issue contains a thematic component titled Life Sciences, Ethics, Innovation and the Future of Law. And while perhaps not the most eloquent of titles, mea culpa in that regard, it would be remiss of me, given the theme, not to take you through the life cycle of this issue. So, issue 46.2 was conceived through quite the conventional means. It was conceived through a love affair, but not quite of the usual kind. It was actually my love affair with the High Court's reasoning in Catanac and Melchior. Yeah. And while out of the interest of time, I won't dive deeply into the facts of that case, what is important to know is that in deciding whether the parents of an unintended child, conceived in the context of medical negligence, can claim damages from that negligent doctor for the cost of raising that child, whom I might add was otherwise healthy, the court turned to consider the relatively long-standing blessing principle, which was emanating out of the United States. The principle essentially provides that the birth of a child is taken to be a blessed event, and to suggest that such an event constitutes harm, injury, or damage would be repugnant to the sanctity and value of life that has come to underpin the operations of the common law. So in considering this argument, the court drew from a spectrum of theological, sociological, and economic and moral values, Spoiler alert, the principle was in essence rejected by the majority and the award of damages upheld. As I read the judgment though, I couldn't help but wonder whether the same decision would have been arrived at if the decision wasn't handed down in 2003, but rather 50, 20, or even only 10 years prior. You see, that's because the nexus of law and the life sciences exposes the interweaving strands of legal dynamism, scientific development, moral fluidity, and human desire to innovate, all of which simultaneously form, reconfigure, and challenge the fabric of our changing society. So, in effect, and while I appreciate that was a bit dense, it was this nexus where the idea for this issue was conceived. I suppose after all conceptions follows a period of gestation. And I hate to break it to you, but this one was quite unremarkable. Like all high on life 18-year-olds, I started reading the Journal of Law and Medicine for fun, as you do. Which, upon reflection, I now realise was effectively my version of what to expect when you're expecting. I lived quite a quiet life, conceptually gestating. That was until one bitterly cold morning in May last year when my friend and editor of issue 45.4, Georgia Fink Brigg, sat me down and asked me one very important question. She said, "Hayden, do you have summer plans?" Thinking I was about to be whisked away on a nice holiday somewhere, I shook my head compulsively. But before you could even say Saint-Tropez, she was instead encouraging me to run for election to this position, and evidently the birth of this conception was thrust upon me. Like all newborns, issue 46.2 has been the recipient of its fair share of nurturing, and it's received such treatment from the entire extended UNSW Law Journal family. Most prolifically, the 27 authors, many of whom I'm glad to say here tonight, produced the rich and diverse scholarship which forms this issue's backbone. So going to the complex nexus of law and the life sciences, the 5 thematic articles in this issue address quite a number of quite riveting themes. So we have articles on methods of recognising animal legal personhood in Australian law, the legal and moral justifications of vaccine mandates, the failures of the regulatory oversight of nanotechnologies, the procedurally and ethically vexed implementation of gene technologies in criminal investigations, and the somewhat problematic evolution of human research ethics committees and their grant of waivers of consent in medical research. Likewise, the 5 general articles in this issue provide a safe refuge for all legal eagles, particularly those fond of qualitative research, which actually happened by accident, not by design. So they all go to address a plethora of emerging points of legal contention, including understandings of governance duties in the Australian charity sector, the admission of intoxication evidence in Victorian rape trials, judicial engagement with constructions of Aboriginality in the sentencing of Indigenous offenders, the continuing social discrimination against the queer community within Australian law, and the possibility of reading a right to disconnect into Australian employment contracts. So to the authors, I say thank you all for trusting us with your important work, and I sincerely hope we've done it justice. Working alongside you all to see your articles go from landing in our inbox through to being published has been both a privilege and an honour. Being a completely student-run law journal, though, our anonymous peer reviewers play a fundamental role in this process, and I thank them greatly for donating their time and expertise to ensure that what we publish is at the very cutting edge of legal scholarship. I was quite surprised when I first joined the executive committee that our student-run leadership structure is not quite a universally known fact within the academy, evidenced through the number of times I personally have been referred to as Dr. or even Professor Clift, which, I mean, no offence to the professors in the room, is quite a troubling thought. But that this is really a result of the professionalism and dedication of our voluntary student editorial board. To our boardies, the Australian Guide to Legal Citation is gospel, and they wouldn't have it any other way. I thank all of them for the many grueling hours they spent unitalicising italicised commas and hunting down seemingly unfindable sources to verify every in-text proposition and every citation in this issue's 2,274 footnotes. None of this would have been possible without you. Moreover, while our independence is a very big source of pride for us at the Journal, we are also very lucky to have 2 human fire blankets in the form of Professors Rosalind Dixon and Gary Edmond as our faculty advisors. I thank both of them very much for their patience and guidance, both within the Journal and beyond that. I must also thank the Dean of UNSW Law and Justice, Professor Andrew Lynch, firstly for his attendance tonight, but also, as Matilda mentioned, his ongoing support of the Journal. We are, of course, in the beautiful office of Corrs Chambers Westgarth, one of our valued premier sponsors. I thank Corrs very much for hosting us tonight and for doing so with such generous hospitality, which we've all seen. I must particularly divert my thanks to the team responsible for organising tonight's event, namely Cass, Casey and Marianne, and of course Eugenia for her kind words earlier. And I also thank our other premier sponsors in Allens, Herbert Smith Freehills and King & Wood Mallisons for their ongoing support. There remains, though, a team of hidden faces who have also given this issue its fair share of TLC. So whether it's our typesetter Kerry, our cover designer John, or Maggie, whose breathtaking print you will see on the first page of the thematic component when you see it, it's been a pleasure to work with all of them. Equally hidden from view, though, is the love and support I've received from my family and friends throughout this process. You've listened to my tired journal rant, often taking the form of obnoxiously long voice messages, which you all know about. Thank you for that, Matilda. And I couldn't be more grateful for your patience and encouragement. I look forward to innovating new excuses to weasel my way out of personal commitments now that I can no longer rely on the Journal. Clearly, this issue has had quite the spoilt upbringing. I suppose, though, now that everything's said and done and the editorial process is quickly being relegated to my memory banks, many of you are probably thinking, is this it when it comes to the life cycle? Like, is this where issue 46.2 comes to die? Well, no, of course not, because tonight's launch marks the beginning of issue 46.2's maturity. And like all good parents, I must know when to let go and let these articles enter the big, not so bad world of legal scholarship. And while I very much look forward to the discussions that these articles will stimulate, it's not lost on me that I am now left a veritable empty nester. That's quite poignant, actually. It's also ironic, given I've equated my time at the Journal with how I imagine it must feel like to be in a 30 or 40-year marriage. Mostly good, but there are days when you wake up in the morning and you look at yourself in the mirror and you just think, why on earth did I ever do this? But in saying that, one doesn't need to look very far to remember why, and that why for me has always been the ever wonderful fellow members of the Executive Committee. Whether it's the team that I entered back in June 2022 in Enrico, Georgia, Kat, Akriti, Darius, Izzy and Cal, or the team that I'm tonight leaving in Ella, Anna, Jessie, Brad, Matilda, Jack and Zong, I quite frankly cannot find a single word in the English language that I feel appropriately reflects the thanks and admiration I owe you. And other than to say that you have made every sacrifice Saturday and 3 a.m. pub deck worthwhile. And I look forward to our friendships lasting long into our eventual shared empty nesterhood. Look, when I started this speech, I started by posing a question. How does one write a speech that is both informative and entertaining? As many of you would have ascertained by now, I'm still trying to figure that out. But I've had fun trying and you've all been wonderful, and I thank you all for turning out in droves tonight to support the Journal. This is actually the largest launch we've had since our kind of pre-COVID era, and it's great to see us have such a triumphant return to form. And you're all part of that, so thank you all again. So with that said, I am now left with one final duty as the editor of this issue of the UNSW Law Journal, and that is to introduce our keynote speaker for this evening. We are incredibly lucky to be joined tonight by the Honourable Justice Robert-Beech Jones. Justice Beech Jones graduated from the Australian National University in 1988 with a Bachelor of Law and Science with honours. Not all that long after graduating, his honour was called to the New South Wales Bar in 1992, where he went on to take silk in 2006. Having enjoyed a lengthy and distinguished career as a leading barrister, his honour was appointed as a judge of the Supreme Court of New South Wales in 2012 and was most recently appointed in 2021 as its Chief Judge at Common Law and as a judge of the New South Wales Court of Appeal. Since joining the bench, His Honour has presided over a number of notable cases concerning the intersection of law and the life sciences, including cases concerning vaccination mandates, DNA evidence and climatic events. As Matilda also mentioned, His Honour also wrote the foreword for this issue, which I express my sincere thanks for. It's a great read and it includes some really fascinating observations, and so I really hope you all enjoy reading it as much as I did. And now in saying that, I actually very much look forward to hearing from Justice Beech Jones, so please join me in bidding His Honour a very warm welcome. Thank you.
Thanks, Hayden. That is actually a rather tough act to follow, I have to say. It has been said, but it bears repeating, the land on which this building is located is the land of the Gadigal people of the Eora Nation, and I pay my respects to their elders, past, present and emerging. I pay my respects to other First Nations people who are present, who may be viewing online. Now, as you've heard, and from the flyer, it describes my talk as a keynote address on the very challenging and it appears hard birth topic of life sciences, ethics, innovation and the future of law, which, my gosh, sounds very impressive. I don't want to disappoint you by saying the first choice for speaker, namely ChatGPT, couldn't be here tonight. It turns out they were too busy drafting student essays and marking them on behalf of members of the faculty. I was able to catch up with them beforehand and I input the title of tonight's launch. Depressingly, they came up with a speech far better than the one I drafted. This is literally true, but the speech concluded with the following, and I quote, "The future of law in the life sciences field will involve a continuous interplay between legal and ethical principles, scientific advancements and societal values, with a focus on promoting innovation while safeguarding individual rights, public health and the greater good. And quite frankly, what is there left to say, and how terrifying is that? It actually means when your university's quantum computer is hooked up to an AI engine, we're all doomed. I'm going to talk about what happens until that terrible time. Part of this speech, I think, was to discuss the theme of the particular launch and my connection to it. I think that is what is now referred to as, quote, lived experience. As you heard, my perceived connection to life sciences stems from my involvement in hearing cases about vaccine mandates, a number of criminal appeals about complex DNA evidence, and although it's not a life science, but it was the result of one, months of absolute purgatory hearing expert evidence on hydrology concerning the flooding at Brisbane. As we judges sometimes like to say, the concept of expertise has a flexible quality. However, being a judge hearing evidence about vaccine efficacy, multi-contributor DNA or hydrology does not make me an expert in any of those areas of endeavour in the same way that a scientist who gives evidence in a court or at an inquiry does not become an expert in the means of proof of facts in civil or criminal litigation. To the extent that I have some background in science, it was my secret other life, which was a bachelor's degree in computing and applied mathematics from as far back as the 1980s. They're not life sciences, but they'll have to do. I'll just share my starkest memory, which is my final year lecturer telling the class that despite the fact that we'd been using mainframe computers, there was a small, tiny minority of computer scientists who believed that the following decades would see a revolution in the use of personal computers and communications. Of course, all of that small, tiny minority became billionaires. I became a lawyer. I never heard of the lecturer again. Sometimes your lecturers don't know much about the future. And in the balance of the talk, I'm going to make a few observations, not so much confined to life sciences, but about the dialogue between courts and science, which is a little bit more in my area, and then move closer to the direct theme of the edition of the journal, just picking up on some of the broader themes about legal responses to scientific advances, especially in the life sciences. I'm going to refer to some of the articles, but I won't butcher them by trying to summarise their contents or repeat my foreword. The articles are too excellent to simply be consumed by a summary in this speech that's no more than a glorified 140-character tweet. Former Chief Justice Gleeson once commenced an address to a medical conference by stating, quote, "When lawyers and doctors meet for professional purposes, it does not end well for one of them. When lawyers and scientists get together, the story is not much different. It can be best understood as two teenagers playing the role of each other's parents and yelling, 'You don't understand me,' at each other." The headline, "Law v Science," is not uncommon, especially recently. What the headline is really referring to is how courts, which is of course a subset of the law, grapple with scientific evidence, especially in criminal trials, something I do have more familiarity with than the life sciences. I can't and I won't descend into the details of any particular current controversy, but at least one level this supposed dialogue of the deaf between the courts and scientists reflects is the difference between proof of facts in litigation and ongoing scientific inquiry, especially into causality. They are very different concepts and processes. Proof of facts in a court is a point-in-time assessment. It is a cliche that the wheels of justice turn slowly. Like most cliches, it's only partly true. It's true in the sense that cases and trials can take a long time to be heard, and regrettably, once the hearing is over, some judgments, and dare I say it, reports from inquiries, can take too long to publish. However, it's not true in the sense that the hearing of a civil case or a criminal trial is a bulldozer, but once it starts, it's very hard to stop. It will keep grinding on and demand that evidence be adduced and arguments be put here and now or forever silenced. Taking time off from a hearing or a trial to seek more empirical evidence or to reflect upon what the evidence proves or disproves is generally not an option. If it does happen, someone has to pay. Now, the process of scientific inquiry, on the other hand, never ends. It continues on in perpetual dialogue with itself. Hypotheses are raised, data is gathered and analysed, and conclusions are drawn, leading to an acceptance, rejection, or revision of the original hypotheses. Sometimes old theories are rejected, sometimes they are refined, or sometimes they are just proved to be a specific case of a more general theory. I cannot think of any area of scientific endeavour where the research has just ceased because a complete and definitive body of knowledge on some topic has now been discovered and the relevant chapter is closed. On the other hand, subject to appeals and various forms of review, courts treat a fact proven or not proven as definitive between the parties who fought over whether that fact existed. Now, just as significantly, court proceedings are not now, and never have been, a singular search for the truth, and definitely not the truth at all costs. Ours is an adversarial system, and that has always accepted that truth is a matter of perspective. This system rejected the concept of a single objective truth long before the development of either quantum mechanics or French existentialism. It is the role of the parties to present their competing versions of the truth, and the court, which in some cases will be a jury, decides which, if any, of those versions of the truth is to be accepted. And even within those confines, in this system, other values, most notably time, cost, relative significance, and most importantly fairness, especially fairness to a person accused of a crime, they all wrestle with the object of learning the truth about some dispute or event. While the concept of completely value-free scientific inquiry into the truth has been questioned, these competing values, as the courts would call them, or compromises, as the critics would describe them, do not have any counterparts when it comes to scientific inquiry. Now, these differences are reflected in two constant and at times mutually inconsistent criticism of the use made of scientific evidence by the courts, especially courts hearing criminal cases. The first criticism is that courts are too deferential to what is presented as expert scientific opinion, regardless of its underlying value. Courts, especially juries, are said to be too easily swayed by the apparent authoritative manner in which scientific evidence is presented. This is often described as the so-called white coat effect. The second criticism is that courts ignore scientific evidence because at best they do not understand it, or at worst they resent any supposed infringement on their authority to decide facts and causes. This criticism holds that courts supposedly prefer outdated, simplistic, or simply wrong modes of reasoning that the scientific evidence is said to have debunked. Now, no doubt each of these critiques has their force in a particular case. They are certainly at their most intense when the issues arise in the context of criminal trials. In civil cases, the presiding judge will at some point have to engage with the scientific evidence and provide reasons for doing so. The reasons can then be scrutinised. With a jury, the sole function of the judge is to decide whether the evidence was admissible and give the jury limited direction on how the evidence is to be considered. But juries don't give reasons, they just give verdicts. This leaves room for debate as to how the verdict was arrived at, and that room is large enough for speculation about the role that scientific evidence may have played in the verdict or how its absence might have affected the verdict. And what is sometimes lost in these debates is that often the issue is not law v science, but science v science. That is, the evaluation of competing views of one scientist or group of scientists compared to another. There is a world of difference between a court rejecting the consensus of scientific evidence on a particular topic on the one hand and rejecting the evidence of a particular scientist or school of scientists on the other. It is a very rare case that the established consensus of scientific opinion will provide the definitive answer to a question of guilt or innocence. Now, the debates have led to various suggestions about reform, including a greater role for trial judges in the evaluation of the reliability of scientific evidence at the time when it's admitted into evidence in a jury trial. The proposal may have merit, but it will represent a very significant consequence for the level of judicial resources allocated for trials. Another proposal involves the use of an independent body to to evaluate forensic evidence sought to be deployed in such trials. Now, a proposal like that would have to be fleshed out before it could be considered properly. On its face, that type of proposal raises questions about how competing scientific opinions are resolved, who gets to resolve them, and the legal significance of that resolution for a particular trial. Now, underlying much of these critiques is a rejection of the adversarial system and an appeal to adopt aspects of the inquisitorial system favoured by many of the European countries. One significant feature of those systems that's often overlooked, along with their very high conviction rates, is that many of those systems do not have a presumption of innocence and almost none have a right to silence. I won't spend any further time discussing those systems, as to implement them would most likely require an amendment to the Constitution, and I think we all realise now how hard that can be. So having got that off my chest, let me make some 5 points about scientific and technological advances and legal responses, particularly in the area of life sciences. The first is that scientific advances, especially in the life sciences, can create and exacerbate conflicts about competing legal and societal values. Affording primacy to individual human rights has been the dominant paradigm subscribed to by the consensus of legal opinion within the bureaucracy and academia over the last few decades, even if the policy responses implemented by the bureaucracy did not always reflect that. There are competing paradigms, for example, paradigms that emphasise the obligations owed by individuals to themselves and each other, or utilitarianism, which emphasises the maximisation of the benefit to society as a whole. They've undoubtedly been operating, but they are rarely articulated in the way that the paradigm that emphasises human rights are. Now, it is hard to believe, particularly as we're gathered here in close proximity, but it is only 21 months ago that regulations came in force across the country which differentiated between those who had at least 2 doses of a COVID vaccine and those who had not in relation to freedom of movement, including freedom to attend employment, what you've heard referred to as the vaccine mandates. Those mandates, and the history of similar mandates going back over a century, is the subject of Kay Wilson and Christopher Rudge's excellent article in this edition, and I cannot recommend it more highly. Now, as that article explains, like in earlier times, there was legal and societal resistance to the mandates. And as I can tell you, the contents of my email inbox today proves the introduction of those mandates still rankles with many people, even though they've been repealed for some time. Who and how various people, organisations and institutions responded to the mandates in terms of appeals to human rights, appeals to mutual obligations, or simple utilitarianism in terms of maximising the benefit to the society as a whole, was at the time interesting and in some cases surprising. What was also interesting and to some extent surprising was how our responses compared to supposedly similar countries like the United States. My simple and hopefully present point is that it was the very significant scientific achievement in developing effective COVID vaccines, especially the mRNA vaccines, in such a short time that brought those differences to the fore. Now, this leads to my second point, which is that scientific and technological advances can undermine our legal values or assumptions, sometimes in quite fundamental ways. And it's most starkly illustrated in the life sciences field by advances in neuroscience. Now, as an example at the extreme end, in 2006, 2 very prominent neuroscientists made the following bold claim, and I quote, what they said was that what neuroscience does and will continue to do at an accelerated pace is elucidate the when, where and how of the processes that cause behaviour, with the result that people may grow up completely used to the idea that every decision is a thoroughly mechanical process, the outcome of which is completely determined by the results of prior mechanical processes, so that in the end, the idea of distinguishing the truly deeply guilty from those who are merely victims of neuronal circumstances will seem pointless. Now, the concluding part of that very bold contention involves a complete rejection of the fundamental basis for criminal culpability, that is, the commission of a crime by the voluntary acts of the offender, known as the actus reus, accompanied by a mental state known as the mens rea. Now, even on my very limited reading, there appears to be a heated debate amongst neuroscientists about the veracity of that claim, but it illustrates where at least some people believe that advances will take us. A perhaps more recent and down-to-earth example of the significance of developments in neuroscience impacting on legal values and assumptions concerns research into the decision-making capacity of young people and its effect on their legal status in terms of rights and obligations. Last year, the Supreme Court of New Zealand held that that country's electoral laws, which provide for a minimum voting age of 18, were inconsistent with the right conferred by Section 19 of the New Zealand Bill of Rights to freedom from discrimination, that right commencing from when a person was 16. That decision was partly based on material that drew on neuroscientific research about the decision-making capacity of young people. Now, a number of academic commentators were alarmed over moves because they're concerned that a move like that to lower the voting age could undermine the protections afforded to young offenders and young people accused of crime. One can see how a proposal to reduce the voting age might sit uneasily with a proposal to raise the age of criminal responsibility. Now, the neuroscientists counter this by pointing to research which compares and contrasts the decision-making capacities of young people in situations calling for deliberation and in the absence of high levels of emotion, such as voting, with a highly charged situation where deliberation is unlikely or difficult, such as when those that surround the commission of a crime. For completely pragmatic reasons, the law attaches consequences in terms of rights and obligations to young people based on whether they are above or below a particular age. But neuroscience paints a far more nuanced picture. Time will tell whether the neuroscience advances to the point that some or all of the current legal differentiations based on age are no longer sustainable. And the third general observation is something of a counterpoint to the second. Namely, we need to be cautious in adapting the common law to address scientific and technological change. I'll step out of the neurosciences and back into the computer science by noting that in Dow Jones and Gutnick, the High Court had to consider what was the proper system of law governing a claim for defamation about an article published by a US-based news service on the internet about a Victorian resident that was downloaded in Victoria. Now, the court reiterated the traditional common law concept of publication and held that publication had a bilateral nature in that the relevant utterance must be comprehended by the reader. This meant that the place of publication was Victoria, where the article was downloaded and read, and the law governing the cause of action was Victorian law. The High Court rejected the US publisher's contention that a new rule of publication for the internet should be adopted so that the publication of the article occurred when it became available at the servers maintained in New Jersey, with the result that New Jersey law governed the outcome. Now, Dow Jones and Gutnick was decided in 2002. I remember at the time reading various articles which were, funnily enough, published in newspapers that had an online presence, which decried the judgment as impractical and the product of outmoded ideas stuck in the 19th century. Dow Jones and Gutnick predated cloud computing. With cloud computing, a document uploaded on the internet can be stored pretty much anywhere, with various backup versions maintained in other parts of the world. With cloud computing, the entire document need not be kept on the one server, but could be split into pieces across many jurisdictions. If the High Court had accepted the publisher's submissions in Dow Jones and Gutnick, then it would have led to the adoption of a totally unworkable common law rule that would have been rendered redundant within record time. Last time I checked, the internet and the World Wide Web seem to be doing just fine. The fourth general point I'll add is that scientific advances, especially in the life sciences, can affect our sense of fairness and equality. In the past, genealogical research yielded knowledge that eliminated any last vestige of the discredited suggestion that there was a biological basis for discrimination between racial groups. However, that type of research can yield information that reveals groups of people are biologically different in ways that were not previously understood. The most obvious example of this is advances in genetic technology, including the mapping of the human genome in the 1990s and early 2000s. This made it possible for the first time to identify people with a genetic predisposition to disease. That discovery yielded the potential for them to be discriminated against in various ways, such as employment or access to insurance. Now, alleviating the unfairness that comes from advances in DNA technology is one aspect of Callum Vitale-Smith's article on investigative genetic genealogy in this edition of the journal. He explores the possibility of a new DNA investigative technique which allows the identification of a suspect in a crime from a pool of donors as remote as third or fourth cousins. This allows for a larger pool of potential suspects which can be refined by other investigative techniques. Of present significance is that approach avoids the identification of a suspect based on DNA obtained from using a close relative that might be kept on a database, something that happens without the donor's consent, and most significantly causes division and recrimination as one very close relative becomes an unwitting genetic informer on another. The approach suggested in this article also minimises the reliance placed on DNA samples stored in the databases because those DNA databases themselves reflect societal inequalities. Now, the fifth and last point that I wanted to make about legal responses to scientific and technological advances is to simply echo an observation made by others and made earlier tonight about the difficulty in calibrating the timing and extent of legal regulation in the face of technological change. As one observer stated, if the regulation is too slow, it can create human health and environmental risks, privacy and other individual rights concerns, or produce an inexplicable background for the economy and technological growth. But if it's too fast, it can lead to a different set of harms by disrupting expectations and stifling innovations. It may be beyond my pay grade, but as far as time can tell, the time to regulate, much less prohibit cryptocurrencies seems to have well and truly passed. It's my biases, but I'm sure it's only a coincidence that we see an increasing reference to cryptocurrencies in money laundering and drug supply cases in the Court of Criminal Appeal. The speed and flexibility of the response to regulators is the subject of the article by Paris Jeffcoat, Carrie Delenia and Elizabeth New about the rise in regulatory risks of the Australian nanotechnology industry. For your information, the reference to nanotechnology is to food additives that contain nanoscale particles. I won't do an injustice by summarising it, especially given I started from a complete base of zero in relation to my knowledge of the use of nanoscale particles in food. I can tell you with confidence by the time you finish, you'll be very well informed. Ethical constraints on medical research are put under the microscope, that's a tiny joke, so to speak, by Lisa Eckstein in her article on human research ethics committees. Those committees appear to play some role of effectively policing privacy principles about the use of patient data, and she puts forward proposals for reform. Putting effective ethical constraints on medical research for biotechnology is not easy. As one commentator put it, the proponents of biotechnologies always have the advantage because they can always rely on the notion of scientific progress to gain authority and legitimacy, with the role of bioethics reduced to becoming a mere mouthpiece or intelligent advocate for science. Another commentator put it quite cynically by saying, quote, the primary moral goal for today's bioethics is to get out of the way. Now, to this point, I've mentioned 4 of the 5 excellent articles in the thematic section. The 5th article, which you heard reference to, is by Jane Kotzman, Morgan Stonebridge and Pauline Christensen, and it takes on the challenging concepts of animals as legal personalities. It is an article that is rich with interesting cases and analogous developments. For a country with rural traditions, the proposal is a tough call, but it's a fascinating read. On the technology front, and indeed a welcome relief from it, Gabriel Golding's compelling article, The Right to Disconnect in Australia, Creating Space for a New Term Implied by Law, postulates the possibility of implying a term in employment contracts, conferring a right on employees to disconnect with a corresponding obligation on employers not to intrude. I think it's an idea's time has come, assuming we can all find the time to do something about it. It is not the efficacy of technological regulation is not the issue in Rosemary Langford and Malcolm Anderson's article, but it's the ethical governance of charities. The authors in that article undertook what must have been a back-breaking study, which you'll have to read about, although for once it appeared to provide some good news in terms of ethical conduct. Now, in the foreword, I grouped the other three articles in the edition under the broad heading of equality before the law, but that categorisation is not a basis to minimise their significance. Emma Genevieve's article on respectable equality, queer discrimination in Australian law, post-marriage equality, is provocative, and it decries the concept of what is described as respectable equality being the provision of queer rights that are qualified by and imbued with cis heteronormative standards. The authors of the article, Indigenous Experience Reports, undertook a massive mountain of research into whether sentencing courts in the Australian Capital Territory substantively engaged with the offender's experience as an Aboriginal or Torres Strait Islander person, that being a minimum requirement of the rule of law. Last, by no means least, Julia Coulter and Luke McNamara et al.'s article on intoxication evidence in rape trials reports on a granular analysis of the significance of intoxication of the complainant, the accused, or both in rape trials in Victoria. That work is important because there must be an ongoing effort to eliminate the role of stereotypical thinking in the deciding of those trials. I'll breach my own rule by repeating something I said in the foreword. What's striking about most of these articles is they're the antithesis of the type of doctrinal analysis of case law that were uniform when I was at law school. And for someone who spends every day reading or writing cases, it was most welcome to read something else. Instead, can I say almost all of these articles, including the article about charities, are based on empirical data obtained by the authors and their colleagues over many arduous weeks and months, or perhaps longer. For that and their outstanding scholarship, can I congratulate all the authors on their work. I would ordinarily try and conclude by saying something profound, but ChatGPT already said it for me. Thank you for attending.
Good evening, my name's Andrew Lynch and I'm the Dean of the Faculty of Law and Justice, and I also would like to acknowledge the traditional owners of the lands on which we're gathered, the Gadigal people of the Eora Nation, and I pay my respects to their elders past and present, and I also add a comment on the support of the faculty for the Uluru Statement from the Heart and the work of many of my colleagues led by Professor Megan Davis towards voice and the forthcoming referendum. The tough acts to follow just keep coming, which was the expression that was used by Justice Beech Jones about Hayden, and I certainly feel that also. I have, though, a much easier and very pleasant job, which is simply to give thanks to our guest speaker, but I always then use the licence to give thanks to pretty much everybody else I want to acknowledge and who I think deserves acknowledgement, which is so many people. But let me begin by thanking the judge for his very erudite comments that the role of the guest speaker is to celebrate and mark the occasion and the achievement of the journal team in creating yet another fabulous collection of academic research. And they do so by whetting appetites for that. And that's particular. I feel this move of having the journal delivered to a different location is a genius one, because everybody really wants to open the covers right now after a speech like that, and we're just going to have to wait a little bit longer. But certainly, someone who hasn't had the fortune yet to see the contents of the journal, I cannot wait to get my hands on it after that speech. And I thank the judge for giving us such a great introduction, but there is a written forward as well, but the introduction he's given us tonight to the ideas there. I mean, as he was speaking, I was thinking about this concept of the tension or intersection between law and science, which he began his comments with by referencing the remarks of Justice Beazley. And normally, I suppose, they're seen as quite distant, but I was suspecting that, of course, even in an age where technology was perhaps less here in our lives and perhaps developed at a much slower pace, there's always been that relationship with law. And in my own lifetime, I think about the miscarriages of justice, most famously in Australia, the Chamberlain case in the 1980s and the role that forensic science played in that, but also some of the infamous miscarriages in the United Kingdom around IRA bombings, the Guildford 4 and the Birmingham 6. And then, of course, we must reflect, I suppose, that as the pace of technological change and life sciences developments and climate science as well continues, that convergence with law just becomes almost every day. It was always there, but it now seems an inescapable connection between the discipline of law and science. And certainly that's something, I suppose, that we think about a lot inside the faculty. And His Honour made the remark about the very empirical basis for so much of the research in the issue. And I think a lot about the work that some of my colleagues and your teachers, if you're a student with us at UNSW, are doing around things like biolegality, forensic evidence, law, technology and innovation through various centres, engagements with the other faculties at UNSW. We do a lot of work, more than some of you would believe, perhaps with the faculties of science and engineering, and that trend will only continue. And of course, many of our students in the LLB program definitely are dual award students and study in both of those faculties. And I think that's really something that's very important to the breadth of expertise both on the faculty staff but also in the classroom discussions that we have. So thank you, Judge, for your remarks tonight and for launching this issue in such a wonderful fashion that means we're all going to rush out and get our hands on it as soon as we can. I also want to thank our wonderful hosts of Corrs Chambers Westgarth. It's always such a pleasure to come to Corrs, and thank you, Eugenia, for your remarks earlier, and the other partners and members of the staff here who are in the room and who have certainly worked very hard to make tonight such an enjoyable and pleasant occasion. We always feel really welcome here. We're so glad to have Corrs as a premier sponsor of the journal. As well as the other partnerships and things that we do, the relationship is really special to us. We think the innovative spirit of Corrs is one that works with UNSW. We sit down and come up with ideas of ways we can work differently together and achieve great things, primarily for our students and their aspirations in terms of entry to the profession. I also do acknowledge and thank our other premier sponsors, our friends at Allens, KWM and Herbert Smith Freehills, for their continued support of the journal. I now move to thank my colleagues, Professors Rosalind Dixon and Gary Edmonds. I'm not sure if either of them are here, but I want to thank the academic advisors of the journal. They've both been in that role for a very long time. And I know that they do it with great expertise, but also great sensitivity, because as Hayden pointed out, the journal is an entirely student-run journal. I think sometimes, as you say, people don't understand that, sometimes contributing authors perhaps, or referees, but the journal fiercely and quite rightly guards its independence. The faculty really respects that independence, and we just happen to be the great beneficiaries of the amazing work that the student body does in producing such an incredibly highly regarded, internationally highly regarded publication. And so when it is said that I'm a supporter of the journal, I always think, how could I not be? It's amazing. You do all this incredible work and we get a lot of reflected glory. So thank you to everybody who has worked on the issue that we're launching tonight, but just generally being part of the journal community. One of the other great joys of these events is that the journal community is very tight, and there are sort of what I call journal alumni who come back. Sometimes they're also university alumni. They have left several years on, but either they work in the firm which is hosting, or they're still going across town to be at a journal launch. It's a very special community, and I really appreciate the connection that the journal forges. I want to thank and acknowledge, particularly amongst that though, is Matilda Grimm, who has the job of being the executive editor. Such an important position, excuse me. that is often the issue editor, and I'm certainly not taking anything away from the issue editor, but they come and they say, I've achieved this, here it is, and then they say, and now I'm out, goodbye, drop mic. But Matilda is there for the long haul. It's the year process of ensuring that the 4 issues of the journal and the forums and the online presence are all maintained. It's a really huge job. She's following in the wake of some fantastic predecessors who I know are here tonight as well. So thank you, Matilda. I know you've got the race is still running, but well done. We're at the halfway mark. But the night is obviously Hayden Cliff's, and many congratulations to Hayden. I loved his speech. I've heard a lot of journal speeches in my time, but the continuous thread of issue 46 to being essentially his baby was one that I thought really is very true. There is a real, it made me think of other issues, and often the issue 2 is the one in my mind. I think Justice Virginia Bell had great fun with 42, which it struck me is now 6 years ago, and she made a pause between the two, lest anyone get confused. It's volume 40, issue 2, and I know who the student editor was for that. So the issues and their editors are something I certainly remember, and Hayden, Volume 46, Issue 2 of the UNSW Law Journal will always be your issue of the journal. It will sit on shelves. It will exist in an online world, probably after we are all moved into some higher cloud-like existence. Your achievement isn't one where you say it's, I don't know what the expression you used was, is it now kaput or is it over? No, it's absolutely launched. And it's launched forever, and it sounds like the work that is contained within it is going to be something that many people will consult over many years, and it will make a difference and a contribution to the advancement of knowledge, as do all the issues of the journal. So our congratulations to you, our thanks to your family and friends for sparing your time. We look forward to meeting them, and we celebrate their achievement in getting you here to this. Thank you for that. We look forward to the launches of new issues as the year goes on, but congratulations to everybody on the journal team. Thank you again to Judge Beech Jones for his remarks, and of course to our wonderful hosts at Corrs Chambers Westgarth. Thank you.
Thank you, Professor Lynch, for, as always, delivering such a kind vote of thanks. And thank you to Justice Beech Jones for delivering that insightful keynote address. So this brings tonight's official proceedings to an end. At this point, I would usually encourage you to pick up your complimentary copy of the journal, but as many of you know, unfortunately, they have not arrived tonight. So I do encourage you to engage with the future of law and access a copy online, which is now available on our website. Please feel free to remain and mingle for another half hour or so. And thank you once again for all coming tonight. Good evening.